Yeah, I think we're recording here. Anyhow, yeah, I forgot to finish what happens at the appeal. So we go to I appeal it, we go to the appellate court, she starts into her same story again. Now keep in mind at the previous trial, I have presented that list that shows that this claim she's going to make about my having evicted her the day after she refused to provide me sexual favors is totally bullshit. She starts in with the same thing again, and I do the same thing. I says, Judge, I says, I want to impeach these lies, this list of lies she's telling, as she presents them, so you can present the proper weight of belief to the next lie she tells. And he says, well, we don't do it that way. She tells her spiel, then you do yours. And I went, I want to be guaranteed that I am going to be able to impeach this. She says, you will. Says, okay. So she runs through her things, and I'm quickly writing down. I mean, I'm listing all these lies she's telling that I'm going to impeach as quick as I can while she's telling them. And we finish up, and I says, okay, first of all, I want to start with the first lie. He goes, well, first of all, Mr. Briller, let's talk about the carpeting now. Hello. Why are we going right to the carpeting? Well, we're going right to the carpeting because this judge has already probably listened to a tape of the previous hearing, been told by the last judge what he's going to do, and if not by the attorney, her attorney, what he's going to do to protect this fraud, which I've decimated in the previous court. I said, I don't want to talk about the carpets. I want to talk about them in the order the fraud she has conducted here in the order she's presented them. He goes, no, well, Mr. Ray, let's just, I said, look, am I going to be guaranteed I'm going to be able to impeach all these other lies after we talk about the carpets? Yeah. So we talk about the carpets, and it's the same thing. He is representing her. This is supposed to be another trial. It's supposed to be her against me. No, he's like, well, Mr. Brailer, how much did you spend? Did you have the carpets clean? Yeah, I had it clean. She had it clean too, but it took a month for the smell to go away. Well, you could have replaced them. I said, I'm busy with these other jobs. I didn't have time to replace them, and they were brand new carpets. I didn't know it was going to take 30 days for the smell to go away. And she speaks up. She goes, may I say something? Which is why the judge has to represent. I agree with Mr. Brailer that if it was cat pee, you would absolutely have to replace the carpets. But this was puppy pee. Hey, she had also, and I relate this to the judge, she had also informed me that she had come to me and asked me why, whether or not there could be something wrong with the water I was providing her. City provides the water. Because she, her dog, and her cat all have had diarrhea for the last 2 weeks, which I'm just, thrilled to hear that they've all been crapping all over my carpets. Not only that, she has overflowed the carpets a few times, and I approve for that. But anyway, we finished talking about the guy, and it's a wash. The judge is just obviously representing her on the carpets. Well, you could have replaced them. You could have mitigated the damage. Well, I didn't know it was going to take 30 days. It ended up taking 30 days. I was showing the place before then, but people had come in and gone, whew, what's that smell? And that was with the windows open all day. You can imagine what it would be like more in the summertime. Anyway, I goes, okay, I'd like to document that all the, impeach all these lies. And he goes, well, Mr. Braley, I'm sorry, but I have other customers coming in. Customers, he calls them. It was the next people that were scheduled. You don't have enough time. I'm taking this under advisement. I'll get back with you. Click. End of appeal. Right to present relevant impeaching evidence. Right to cross-examination. Huh? Right to a trial by an impartial trier. All bullshit. Needless to say, I lose the appeal. Goes on beyond that. So I'm ordered to come up and show, present, provide where my wealth is hidden, right? So I show up. We're ordered to all go out in the hall with our prospective, the person who won the suit against us, and provide them, where our banks are and all that stuff. Now, before we go into the office for this thing where you present your evidence, which is a separate hearing, I present her with this 8-page document, which I'm going to provide the court, intend to provide the court, an 8-pager on the conflict of interest and the violation of the rights by the previous courts and all the way back through the Moore case. And I give that to her, and by the way, I go, Mrs. Moore, you know, I just don't know whether, you know, what are the thank you. I mean, you know, we've spent so much time talking to each other over coffee and wine. I'm sure I've related my intent to document you know, do a documentary on the courts, organized criminal racketeering activity against the public, their treason and collusion, and it's like, after having heard this, you have, you know, I don't know if you're working for me or thinking you're working against me, but, you know, I could not have provided a better documentary, a better litany of fraud than you have provided with which I have now tested these courts. And she goes, what do you mean? You don't hate me? You don't? I said, Mrs. Moore, I love you. I love you. You know, this is, thank you. You know, so we go back, we go in there and we go out, and she's got this list of questions she's asking me, and she asked me a couple questions, and I give her the answers, and then I said, by the way, Mrs. Moore, I don't want you to, you nor the court to be misled by my providing you these answers to think that I am granting you any authority in this or any other matter, okay? And she goes, oh, and we're out in the hallway, right? She takes this piece of paper and she runs back into the judge, you know, like the hallway's full with all the people that have been sent out into the hallway to do this one act. They hold a hearing for everybody that's got to do that at the same time. And she goes up to the judge and goes, oh, Mr. Brayler says, blah, blah, blah. You know, I forget what she said even, but, you know, Mr. Brayler said this court has no authority, blah, blah, blah. And she's waving this piece of paper, right, and I'm walking in behind her. And, you know, the bailiff takes it, she hands it to the judge, and the judge reads a little bit of it, and he goes, Mr. Brayler, do you want me to read this? I went, oh yeah, sure. And so he goes back in the back, and they read it. And what I'm finding out from these hearings is when you provide them something in writing, a reasonable amount, they actually have to go back, and they go back in their chambers and they read it, or they have somebody read it, I don't know. But I have actually, when I do these, what I do is I sit out there and I read it while they're in there purporting to read it, to see if they stay out the amount it takes to really read it, and it appears that they do. So anyway, he comes back in and he goes, okay, Mr. Brayler, let me get this straight. So you're refusing to provide her information. I says, no, I haven't refused to provide her any information. He says, well, she said, I says, no. I says, she asked me the questions and I just interjected after I answered a few questions and said, and to remind her that what I'm doing here does not grant that the court should not be misled, nor should she to believe that I'm granting you any authority to, you know, take my funds or anything. And he goes, well, Mr. Brayler, so are you willing to go out there and furnish her the information? I says, sure. And he says, will you answer all her questions? I said, well, that depends. He says, what do you mean it depends? I says, it depends on the question. I don't know what she's going to ask me yet. And he goes, okay, Mr. Brayler, I can see you're not going to cooperate here. I'm finding you in contempt of court. And so they find me in contempt of court, which meant, you know, I'm overjoyed, you know. So we have a contempt of court hearing. Now I'm charged with contempt of court. And you know, you come in and, you know, you could be found for a year in jail and $3,000, $4,000, $5,000 fine, whatever it is, you know. And I, you know, now I give him an 8-pager on the conflict of interest of the court here, pointing out that, you know, there's a collusion, a conspiracy, and all that shit. And you know, each of these cases, I'm heavily into. In other words, it always starts out with me telling the court they need to recuse themselves in this matter, this conflict of interest, which I've more than documented. And as a matter of fact, I even at one trial submitted the law on recusal, and basically it says a judge, you know, if a citizen or a party even, you know, claims without any evidence at all that there's a conflict of interest, the judge shall recuse himself in order to maintain the belief the public has in the court system. Okay, in other words, if they say there's a conflict of interest, recuse yourself, give them another job.